Now, Mr. Lord, before we advance further, we'd like to reculer pour mieux sauter. And we've had some thoughts overnight about the very first point, which I think, in fairness to you and also Mr. Chivers, we should raise with you at the earliest opportunity. And I'll ask Lord Briggs to explain what the points are.
Mr. Lord, assume purely for the purposes of argument that the relevant net asset value determinations, I think December, January and February, were vitiated by an internal fraud that is not affected by the Fairfield decision and that line of cases. But that they weren't such as to make it simply not a valuation at all. The first question for you is, would the unravelling all that such a tainting might give rise to make the valuations void or voidable? And the second question is, would they have to be done in proceedings for that purpose to set them aside, and in that case with an appropriate joinder of interested parties? And thirdly, assuming that none of that was assuming that it's voidable rather than void, is it a discretionary remedy to set them aside from the court? And if it is, would the court be able to, or should it be minded to, as a matter for your submission, impose repayment of any sums received under those valuations by the person seeking to set them aside as a condition of setting them aside?
Right, doing the best I can. My answer to your Lordship's first point is, in my submission, they would be purely voidable. Yes, is that they would be purely voidable. It's not, in our analysis, actually a question of vitiating the contract. And this is the point that the Court of Appeal talk about. There is not a new contract. No. There is just a valuation. Yeah. That is all that has happened. And therefore, when one talks about avoiding or whatever a contract, that's not the correct analysis. There is simply a valuation. And that valuation, if everything my learned friend says is right, is a valuation that might be capable of being set aside. But there would have to be a procedure to do that. And in this case, there would have to be a procedure whereby there were proceedings brought. So if, for example, my learned friend, his clients wanted to set it aside, in my submission, it must be a precondition of them being able to do that they would first of all hand their money back. Because as my learned friend accepts, if he's right, he should never have got the redemption payments he got. They would have been repayable, but the simple fact of the matter is they are not repayable, because if we were to bring a claim now at common law for payment made under a mistake, we're now out with the 6-year time period. So, my Lord, I hope that's my answers to your question. My Lord, can I just raise 3 points from yesterday, hopefully very quickly? We were discussing the question of the valuation of the NAV, and in particular the value that was placed on the swaps. And questions were posed to me as what evidence was there before the court. Now, there was some evidence, and that was the evidence of Mr. Stokoe, which was unchallenged, which is in volume 4 of it's an additional documents bundle. I think electronically it's 1691.16.
Volume 4, the pages are all numbered 1199.
They are, but electronically I've been told that it's a different number. But it's paragraph 63 to 67, my lords.
Sorry, what page is it in?
1199.16.
16, thank you very much.
Sorry, 1199 electronic?
No, electronically, my lord, I've been told it's 1691.16.
Oh, 1691.16. All right, let's try it.
should have paragraphs 63 to 67 of Mr. Stokoe's witness statement. If I can just invite you to very quickly read
All right, I'm
that.
afraid. I'm going to have recourse to paper. Can you give me the volume then?
Yes, it's Hearing Bundle Volume 4,
Thank you.
and then page 16 of that bundle.
Thank you. Yeah.
Sorry, Mr. Lord, what's the particular point we're
But my
focusing on here?
But, my Lord, I just wanted you to see that is the evidence, unchallenged evidence, of the then liquidator about what he'd found out. And then what I've provided your lordships with are the documents he refers you to, which are the swap confirmations and tickets. And I've put them in a slightly different order in this clip. But if you look at the front page 467, this is something that was provided by Weavering Capital Fund Limited. That is the BVI company. And if you see on the first page, it's purported to be signed by Mr. Ekstrom, who is a director of that company. The evidence was that Mr. Ekstrom knew nothing about it, and that therefore his signature was probably a forgery, and therefore presumably forged by Mr. Magnus Peterson. But this is a document that is coming from the BVI company. And you see a number of those letters, and then if you turn forward in the bundle, you get at page 433, you get a interest rate confirmation in relation to a particular swap.
Did you say 433?
Yes.
Mine stopped.
It does, my lord, because I put them in, I don't know why, I put them in the different order so that you saw the confirmations,
yes,
the forged
I've got it.
confirmations first.
Yes, thank you.
Then 433,
Yes.
you have an interest rate swap confirmation,
Yeah.
and then over the page you have the ticket. Which makes the point I was making to you, my lords, yesterday, that these were real trades. They were just valueless as such. And if the only other thing I want to point out to your lordships is 460, you'll see one of these confirmations. And at the top of the page, you can see it being faxed. GMT time +1. So it looks like it's been faxed directly to Ireland, which is where PNC were. And the simple point I want to make, and then move on, is this is the information that PNC were receiving about the swaps. They were receiving it from the counterparty, no doubt because they wanted independent verification of the trades. And it is this information that comes from the BVI company that is the basis for the wrong valuations. And that's why, in my submission, this is not at all a case of internal fraud. It's a case of external fraud. Because in the same way as in Fairfield, it was Blimis, or Mr. Madoff, that was providing the false information. Here, it is Weavering Capital Fund Limited, the BVI company, that is providing the administrators with the information. They then do their task honestly, but they make a mistake. Lords, that's all I wanted to say about that. The second point I wanted to deal with very quickly is Lord Reid asked me a question about Eurocell, and it's page 166 of the transcript, and I said I would just look at it overnight. The point, I don't think we need to go back to the judgment, is I referred your lordships to paragraphs 35 and 37, and the two changes that Lord Walker was talking about. And my Lord, Lord Reid, quite rightly made the point that earlier in paragraph 29, Lord Walker had been talking about the changes to the Life Assurance Companies Act. But my Lords, in my submission, if you read carefully, in paragraph 35, what Lord Walker is talking about are the two changes. The first is the addition of as they fall due, and the second change is the change to the other section in relation to contingent liabilities. It is those two changes he's talking about in paragraph 37, and in the first 11 lines he's talking about the first change, as they fall due, and in the remainder of the paragraph he's talking about the contingent liabilities change. And the point I was making is, therefore, when he says in line 3, the changes made no significant change in the law and simply underlined that the cash flow test is looking at debts falling due from time to time and in the reasonably near future, what he says is directly relevant to section 93 and the cash flow test in Cayman. My Lords, the third point I wanted to make is that the schedule, the appendix to the Statement of Facts and Issues that I handed up, the big copy, to you yesterday, pages 2 to 4, which we didn't take you to, and I don't urge you to go to, have details of the January to March redeemers. But what I handed up to you contains the identity of the actual shareholders, and it shouldn't have done. That evidence was redacted before the court. It was redacted because it is confidential. The reason why the identity of the December redeemers was before the court and was not redacted is because their identity was all public information, because they had all been sued in the other preference actions. So I apologise for that. I gave you some information that I shouldn't have done. It wasn't before the judge, and I'd be grateful if you would ignore it. Well, Lords, that deals with matters from yesterday. I got to issue 4, the question of with a view, and can I invite your Lordships to turn to volume 5 of the record and the Statement of Facts and Issues. And in particular, page 1578 of the record, paragraph 611 of the Statement of Facts and Issues.
Sorry, paragraph?
Paragraph 611.
Thank you.
And it's the last 5 lines that I want to draw to your Lordship's attention. The judge found that Magnus Peterson must have known by the end of December that the company would not be in a position to pay all the December 2008 redeemers by instalments or otherwise, let alone the amounts about to fall due. Turning over the page, you'll see at 613 is the 7th of January letter that my learned friend took you to. Paragraph 6.19 are the minutes of the board meeting. 620, there's a reference to various emails and the conclusions of the judge. All decisions were made by Magnus. That's his finding about Magnus being a de facto director. Secondly, the company did not have sufficient funds. Thirdly, others were looking to the swaps to fund the redemptions, and Magnus confirmed that some of the swaps would be closed out. And finally, some redeemers were putting pressure on PNC and WC UK to pay them, but there did not appear to be any pressure from my learned friend's clients. My Lords, then finally, 1015, in addition, the judge held that the redemption payments were all made in the knowledge on the part of Magnus Peterson that the company was unable to pay its debts. However, given the judge's finding that there was a specific intention to prefer SEB, it was not necessary for him to go on and decide the other points. And then, my Lords, finally, page 20, page 1591, the list of issues, the actual issue. Was the Court of Appeal correct that in making the second and third payments in accordance with the payment policy, and at a time when Magnus Peterson knew that the company had no prospect of paying the January and February redeemers in full, and when the proper course would have been to suspend redemptions or that should be, or liquidate the company had the requisite intention. And my lords, we say that question answers itself. Magnus Petersen knew that the swaps were fraudulent. He knew that the company had no prospect of paying the January and February redeemers. He knew that the proper course was to suspend redemptions or liquidate the company, i.e., he knew that the company was insolvent and faced imminent liquidation. But he still purported to adopt the payment policy, which he knew would inevitably result in those creditors being preferred. Now, my learned friend said what he did had that effect, but he takes issue with any suggestion that that was designed or the intended effect. But my lords, it was, because it was the policy. It was the payment policy. It was absolutely what was intended. Now, my lords, I said he purported to adopt the payment policy because, as your lordships know, he did not pay all of the December redeemers in full. And we saw that from the big schedule. The first three were only paid 25%. I think one of them got another further payment of 10 million. And therefore, the payments that were effected were a preference over those December redeemers who were not paid in full, and were also a preference over the January redeemers, and indeed the February redeemers, depending upon the precise date of the payment. So that's why we say the question answers itself. Having adopted this policy at a time when the judge found he shouldn't have adopted any such policy, no appeal from that finding, he should have suspended redemptions and considered putting the company into liquidation. Instead, he adopted a policy that was always going to result in certain creditors being preferred over the others. Now, my lords, in my learned friend's case, they downplay on a number of occasions the findings of the judge and the Court of Appeal, because they suggest that the Court of Appeal found that they were preferences simply because they were paid when Magnus Petersen knew that the company was unable to pay its debts. But as I've illustrated to your lordships, he knew a lot more than that. And therefore, the references in paragraph 100, 106, 112 and 114 of my learned friend's case are wrong because they misstate the findings of the judge as summarised then by the Court of Appeal. Now, my lords, the same point is made in paragraph 54 of our case about the notice of appeal itself. Our case is at 1655 of the record in volume 5. And I say the notice of appeal misrepresents the findings of the Court of Appeal. The time that the second and third payments were made, Magnus Petersen did not only know that the January 2000 redeemers remained unpaid, he knew that not all of the December redeemers has been paid. I refer to the passage in the Statement of Facts and Issues. And then the reference to what the trial judge says about Magnus Petersen being aware of the need to treat all investors equally. And my lords, then in the case, just so your lordships see, we set out, going back in our case, in paragraph 49, page 1649 of the bundle, a number of principles that we say can be derived from the authorities. Now, my lords, I don't have time to take you to the authorities. We've set it out there, and in fact, I don't understand any of these principles, in fact, to be contentious. Now, my lords, my learned friends rely upon a passage in recuts which is set out in paragraph 107 of their case. My Lords, that's page 1625 of the record. But in fact, that's not inconsistent with anything we say. If you see the quote on paragraph 107, where a debtor, my learned friend took you to this, owing money in all directions, has also robbed his employer's till, he may, knowing himself to be insolvent, elect to reimburse the till in order that when the crash comes, the damaging factor of his robbery may not be discovered. Or a debtor may elect to make a particular payment under pressure of some threat, or to obtain for himself some immediate and material benefit, or to fulfill some particular obligation. In these cases, the reason for the payment affects essentially the intention is in making it. Now, my Lords, we don't disagree with that. In our submission, the correct analysis is that normally when a debtor pays somebody ahead of others in circumstances when the debtor knows he cannot pay his debts, that will amount to a preference because it will have been made with a view. And that is even more the case where, as is the case here, Magnus Petersen knew that the end was nigh and the fraud was about to be discovered. But there may be circumstances that mitigate against that intention. For example, pressure. There was no pressure in this case, and as is made clear by the authorities, the absence of pressure itself can demonstrate the intention to prefer. But what was the situation in our case is not the same as the example in Re-Cuts of the person who has robbed his employer's till and puts the money back. That is very different, of course. If somebody has robbed the till and puts the money back in the hope that his robbery will never be discovered, one can see that his dominant intention was to try and evade being discovered as a thief. That is not Magnus Petersen's case. There's nothing he could do about the swaps. They were inevitably going to be discovered. The same can be said for the case that my learned friend took you to of Sharp and Jackson. That was where the debtor had caused breaches of trust, and he knew that they were about to be discovered. However, he purported to make them good. He knew that they were still going to be discovered, but he hoped the fact that he'd replenished the trust fund would curry favour with others and that they wouldn't sue him. Again, not our case at all. Our case is simply that Magnus Petersen knew all the things that the judge found he knew that the end was nigh, and then deliberately adopted a policy that had the effect of preferring the December redeemers over the January and February redeemers. And what's more, because he didn't adopt the policy in full, and it would appear from the 22nd of February minutes that was because, as discussed yesterday, he may have thought it was better to pay the smaller creditors and leave the three largest creditors outstanding. The effect of what he did was to prefer those creditors over the December redeemers who were not paid in full. So, my Lords, we say that the Court of Appeal in paragraph 56 of their judgment got it absolutely right. The only thing I would say, my Lords, in relation to that, and that's at volume 1 of the appeal, page 31 of the judgment, paragraph 56 of the judgment, but on page 56, they refer to the policy, but I would add in the fact that is missing from the judgment about it also being a preference over the December redeemers that were not paid in full. But we say there the Court of Appeal have got it spot on. In paragraph 57, they go on to raise the additional point that we had raised by way of a respondent's notice, which is whether the fact of payment in knowledge of insolvency is sufficient without more to found an inference of intention to prefer. Again, your Lordships don't have to decide that point, But for what it's worth, my submission is that that is a preference if somebody makes a payment knowing that the company is insolvent and knowing that the effect of that payment will be in fact to prefer, then that will be a preference absent some other explanation, such as pressure. But again, that is not something that your lordships have to decide, is not something that the Court of Appeal felt it was necessary to decide, because we have all of the other factors in play in our case, and in particular the fact that Magnus Petersen knew that the proper course was not to make any payments at all. So, my lords, that's all I was going to say on issue 4 with a view. My lords, there's a section F in my learned friend's case that he didn't develop orally. We deal with it in paragraph 60 onwards in our case. This is the other creditors point, and we make the point that it's not in the notice of appeal and therefore is not a matter before your lordships. We also refer to paragraphs 192 to 197 of the trial judge's judgment, and if your lordships are interested, I commend that to you, and he explains why in any event the points of academic interest only. So, my lord, that takes me on to the amendment issue. My lords, this was not a point that was pursued at trial. It was raised at a very late stage before the Court of Appeal and not dealt with in the skeleton arguments before them. And in the light of the other findings, the Court of Appeal didn't find it necessary to deal with the point. My lord, it is fundamentally misconceived. If one looks at paragraph 62 of our case, page 1659 of the record, the premise of it is that the Court of Appeal ought to have concluded that the second and third SEB redemption payments were not preferential. And that's where it goes wrong. My learned friend relies upon the case of Lewis and Hyde, and he took you to that case. However, in that case, what had happened was that the payment that was made to the individual was not, in fact, a preference payment, because although he was paid early, if the 7 days required by the bank had played itself out, he would still have been paid, so that the finding is that the payment was not, as a matter of fact, a preferential payment. And perhaps we should just have a look at Lewis and Hyde. It's in Authorities Bundle 7. Tab 20.
Page?
Page 2273, my lord. If your lordship see in the head note, 3 lines down, in the ordinary course of business, the company required 7 days' notice for withdrawals and repaid deposits by cheques which it had itself drawn. On 2nd of February, an employee of the company arranged for immediate repayment to H. So those are the essential facts, and it's dealt with, page 2275, page 96 of the judgment. What I've just read to you is explained between B and D. And then in the next paragraph, in January and February, Prudential was in financial difficulties. An application to wind up was filed, provisional liquidator appointed. From 2nd of February until 21st of February, Prudential continued to trade in the ordinary way. During that period, accepted over 500,000 New Zealand dollars by way of deposits and repaid over 2 million. Therefore, even if Mr. Hyde had been required to wait for 7 days for repayment and also for a further period in order to enable a cheque drawn by Prudential itself to be cleared, he would have repaid his deposits in full. So, The finding is that the payment was not a preference. And what the rest of the judgment goes on to consider is whether or not it is necessary to found a claim based on preference that the payment is in fact a preference. And not surprisingly, the Privy Council say it is necessary. But that's different from our case, because my learned friends do not suggest that the first SEB payment, which is what this point is concerned with, was not a preference. It was. As a matter of fact, it preferred SEB over the December redeemers who were not paid in full, and over the January and February redeemers. They do not appeal the findings that the second and third redemption payments were in fact a preference. They were. What they say in relation to the second and third SEB redemption payments is they were not made with a view. That's their appeal. So if they were to succeed in that, your lordships will have found that the second and third redemption payments were not made with a view, but that does not affect in any way the judge's finding that the first payment most certainly was made with a view. Because just like the other 5 Swedish redeemers, Magnus Peterson wanted to prefer them because he anticipated that if they received their redemption proceeds, they would then use those proceeds to invest in another fund, a Swedish fund that he was managing called the Ranta Hedge Fund. So the amendment point doesn't assist my learned friends because it doesn't alter the fact that the first SEB payment was made with a view. They don't appeal that. And it doesn't alter the fact that it was, in fact, a preference. And my lords, that's the amendment point. If I can come on to the defences. My lord, the first point we make is that Section 145 is a statutory cause of action. Without Section 145, there would be no basis for the liquidators seeking to reclaim the monies on the basis that they do before your lordships and did before the trial judge. In order to succeed in the claim, the various ingredients of the cause of action are found in the section itself. Has to be made with a view, has to amount to a preference over other creditors. It is not a claim in unjust enrichment. Therefore, there is simply no basis for my learned friends to say we have a defence because we were not enriched. That's not the claim that is being made against them. And we say the same in relation to a change of position defence. That is a common law defence to a common law claim for money had and received or money paid under a mistake.
First, the difficulty is that Section 145 doesn't say anything about remedies or causes of action. It simply says that every such payment shall be invalid.
My lord, it does. Yes, I fully accept that. It says it's invalid, therefore it must be paid back.
It does, that's what it doesn't say.
It doesn't. I accept that. It simply says it's invalid. Yes.
So the unjust enrichment claim, it's set against you, flows from the fact that they have received money under a payment which was invalid.
Yes. Yes, but the point is, my lord, we are not claiming in unjust enrichment.
Oh.
That's not our claim. Our claim is pursuant to Section 145. It was a preference. If I'm right about that, what the section says is it is invalid.
Yeah.
And then in my submission, all that the court can order and should order is that the payment is made back.
But you can't simply make that assertion. I mean, Mr. Chiver's argument is that is it in reality the only basis for demanding that the appellants repay money which was paid invalidly, can only be an action for what used to be called money hadn't received and nowadays would be called unjust enrichment.
Well, my lords, I understand that. Can I just develop the reasons why I say those defences are not available? The first point is the point I've just made, which is that there's nothing in the section, but I fully take my lord's point that there's nothing either way. But first of all, compare the position in England today, because in England it's very different.
Well, yes, but in England today there is a statutory scheme.
No, I accept
and
that.
Mr. Chivers took us to older cases before there was a statutory scheme, which he said supported his submission that the remedy was based on, well, as it was put in those cases, money hadn't received. It was a Moses and McFarlane claim.
My lords, I accept that what is said in those cases, the Australian cases, the ones in his supplemental bundle, do seem to suggest that the cause of action is based on common law. Those cases do not deal specifically with the question of remedy. The cases that deal with the question of remedy is the case of Rose and the recent Ahmed decision in the Court of Appeal, which I will come on to. But all I was going to say about the first cases, he says, is they don't tell you anything whatsoever about the remedy. The point I wanted to make about the bankruptcy legislation generally is that when the draftsman did want to provide some sort of defence in the past, he did so. And one can see that from the Bankruptcy Act 1869, which is in Bundle 8 of the Bundle of Authorities, tab 52, page 2824 to 5 of the bundle. And this is section 92. Avoidance of fraudulent preferences. And the only words I wanted to draw to your Lordship's attention are the concluding words of the section at the top of 2825. But this section shall not affect the rights of a purchaser, payee, or encumbrancer in good faith and for valuable consideration. So, my lords, we see there that in the context of bankruptcy or insolvency legislation, where the draftsman intends there to be a specific defence, it is referred to. And, my lords, in my submission, as a matter of principle, and indeed of public policy, there's no basis for such a defence. The purpose of Section 145 is on vindicating the statutory regime for the benefit of all of the creditors. It is not based at all on the fact that a particular creditor has been unjustly enriched. That's not what it's looking at. It's looking at the statutory regime whereby all creditors should be treated equally. That is the purpose of it. And we refer in paragraph 71 of our case to words to that effect in Lewis and Hyde. The avoidance or the effect of the invalidity is to restore to the estate that which has been wrongly given to the debtor. It's irrelevant to that policy what the creditor who received the money has done with it. What the legislation is aiming at is getting the money back in that should not have gone out in order that all of the creditors, including this particular creditor, should receive his or her fair share of the estate. Whereas,
looking at the list of about 50 December redeemers, would it be reasonable to infer that they're all, or almost all, nominees?
My Lord, it's difficult to see, but one can certainly see that a significant number of them are. And of course, the point is that if Mr. Shivers is right, when you have hedge funds of this kind, frequently the investors will be nominees on behalf of other investors. And if there will always be a defence of change of position or unjust enrichment, then you have cut through a great deal of the effect of this preference provision, because it will simply be impossible, because a vast majority of the investors will simply say, well, it wasn't me, I wasn't enriched, therefore I've got a perfectly good defence.
Well, I mean, there's quite a. It doesn't follow automatically from the remedy lying in unjust enrichment that a nominee. Well, at least there's an issue there about whether a nominee is or is not enriched.
Yes, but in my submission, 9 times out of 10, the nominee will say, I had the money for 24 hours or less, I paid it on, and now I've changed my position. And therefore, you might as well rip up paragraph 145, because in most cases it's not going to work. But my Lord, there's another point.
Well, why does it not work against the transferee?
Well, the difficulty with that is sometimes the company or the liquidators may know, sometimes they won't know. And therefore they've got to go on a whole investigation into working out who the real beneficial owners of these shares are. And my Lords, that's contrary to a whole host of cases here that say, quite rightly, that a company is not concerned with beneficial ownership of the shares. The company is only concerned with the legal owner. My Lords, that's the position here, and it's also the position in Cayman. And if I can hand up to your Lordships.
Are we here talking about legal owners of shares?
Yes.
Or the persons who are its creditors at law rather than the beneficiaries of the debt?
We are looking at who the shareholders are, because in this case, it is the shareholders who receive, they cease to be shareholders, they become creditors.
They become creditors by the time.
But then it is those people who receive the redemption proceeds. And we refer in our case to an English authority, 38 Building, which is a case on preference, where the judge says, I'm not concerned at all about who the beneficial owners are. Of course I'm not. I'm only concerned with who the legal owners are. This, the case of Hanoun, was a case where the petitioner was not the shareholder of the fund, but was the beneficiary under a bare trust. So the trustee was the legal owner of the shares, and the petitioner sought to wind up the trust on the just and equitable ground. And the court held that the petitioner did not have locus standi to petition. And in paragraph 4 of the judgment, Mr. Justice Henderson says, it's well established that where a trustee is the legal owner of shares in a company, a beneficiary of the trust is not a contributory of that company, and he refers to a whole host of authorities. So the position is the same position as here. A company is simply not concerned with anything underlying the legal ownership. So that when a redemption payment is made, it is made to the legal owner of the shares. In this case, and there's no dispute about it, the legal owner of the shares was SEB. And the company is not concerned with what SEB does thereafter. The English case that we refer to in paragraph 78 of our skeleton is the 38 Building Limited case. That is in bundle 8, tab 37, which is page 2613 of the record. My Lords, this was a preference claim. And the passage I wanted to draw to your Lordship's attention is on page 2619, between the letters G and H. In my judgment, on its true construction, section 2394 is, as Mr. Randall contends, looking to identify a creditor in the legal sense of that word, and then treats repayment of that creditor, or whatever else the relevant transaction, as the giving of a preference to that creditor. At that stage, it matters not whether that creditor is a creditor in a trust capacity or in a beneficial capacity. And my Lords, this issue arose in a Canadian case called Principal Group against Anderson, which is in bundle 7 of the authorities, behind tab 26, page 2457. And reading from the headnote, a corporation paid investments which certain investors held in one plan in full within 90 days of the corporation's bankruptcy. The trustee in bankruptcy sued to recover the monies so paid out almost 6 years later, arguing that they were a fraudulent preference, contrary to section 95. The Chambers judge held that there was a fraudulent preference and ordered the monies to be repaid but denied interest on the claim. Some of the payees who were innocent of fraudulent intent appealed, arguing the defence of change of position. The defence of change of position does not apply to statutory proceedings such as those set out in the Act, which impose a duty on the trustee to treat all creditors equally and to collect the property of the bankrupt. Those duties are incompatible with the defence of change of position. And, my Lords, you see in the judgments, page 2459, letter B, the appellants do not question the finding of a fraudulent preference. Appeal is confined to a different point, and that's the change of position. Then D, counsel for the appellants conceded that his careful research had not uncovered any authority applying such a defence of change of position to a suit by a trustee under the Act to recover monies paid by the bankrupt. In view of the enormous volume of bankruptcy litigation in Canada in the last generation or two, that alone must be significant. Well, my Lords, I could add to that. There's no case in England, there's no case in Cayman, there's no case in the BVI, etc., etc. But we need not stop there, F. The respondent...
It rather looks from page 2458 in the bundle between letters G and H, as though this was, properly speaking, a statutory cause of action. Section 95 of the Act, it says, allows such a suit. I mean, we don't have the provision, but it rather looks as though there was a statutory remedy.
I don't read from allow such a suit that there was anything more than a section akin to section 145.
Well, that might be important.
Yes.
Lord. No, my Lords, if you look on 233 at C, the Act does more than forbid preferences and allow a suit to recover them. It makes such payments fraudulent and void. If they are void, then no property passed and the payees are in possession of the bankrupt's property. The duty of the trustee to collect the property of the bankrupt is elementary. So, my Lords, that suggests that the provision is more or less the same as the Cayman provision. But, my Lords, the passage I wanted to refer you to is on page 2459F. The respondent argues that there is a short answer to these defences of change of position. It says that such defences have no application to these statutory proceedings. It may be that a century and a half ago suits to undue fraudulent preferences were a creation of the courts, but that time is long past. There is much to support that argument, especially when one reads section 95. It does far more than allow a suit. It reverses the onus of proof, sets an arbitrary time limit for that reversal, and gives the cause of the action to the trustee in bankruptcy. And that is, of course, part of a very detailed, closely interwoven statutory scheme involving the licensing and appointment of trustees to collect and distribute property. My Lords, they then refer to two public law cases, Maritime Electric and Canero Hydroelectric, and then reach the conclusion that at 233B, that I just referred your Lordships to, and then over the page, 2462, 2 lines down, it's true that the present appellants had no bad motive, though they must surely have realised that the timing and circumstances were peculiar. But to let certain of the investors in this employee investment plan keep their early repayments when the rest had to put theirs back would seem to fly in the face of all the principles set out above. The whole idea of the defence of change of position is that the equity lies with the payee and not with the payor who wants to get back his payment. Where a trustee in bankruptcy carries out a duty to sue to undo a fraudulent payment, it is difficult to see that change of position makes the trustee's suit inequitable. Now, my Lords, that case is followed by another Canadian case, Retitan Investments, which is in tab 38, but I don't think we need go to. My Lords, what I did want to show your Lordships quickly is what Professor Good says about this in one of the essays in memory of Peter Burks. This is in volume 8 of the Authorities, tab 61. And this essay was produced in 2008.
Page?
It begins at 2860.
Sorry, I didn't quite catch it.
2860.
Thank you.
But I wanted to take your Lordships to 2868. Under the heading, The General Approach to Common Law Defences to a Statutory Claim. And the second paragraph, in asserting a defence such as estoppel, change of position or bona fide purchaser in answer to a statutory claim, whether restitution or otherwise, there are at least 3 obstacles. First, it might be said that where statute provides a remedy, a party cannot be precluded from invoking it by some common law principle. And then he explains that. And then 4 lines from the bottom, the other 2 obstacles are more formidable. The first is whilst common law defences against a statute may be available in litigation between private parties when no others have an interest, it is quite another matter where the statutory provisions in question are concerned to protect the wider interests of the public or a section of the public. In such case, neither estoppel nor change of position should be available as a defence. The court's task is to implement the policy of the statute. As we have seen, the insolvency avoidance provisions are designed to ensure pari passu distribution. To allow such a defence would be to promote the interests of a particular party who had received a benefit to which he was not entitled over those of the general body of creditors whom the statute is designed to protect. The second objection doesn't apply to Cayman because that's where the statute itself contains detailed remedial provisions, as the English preference provisions do. But I do rely upon what Professor Good says about the first and second obstacles. And he deals particularly with the English provisions at page 2871. But my Lords have to bear in mind, in the light of what he's saying, that of course 238, 239 do contain detailed provisions about the remedy. But that doesn't mean that what he says is of no value. He says there's been no reported case dealing with the availability of common law restitutionary defences. The question therefore has to be answered by reference to the policy. And then he goes on to explain the policy, and I'm not going to read it all to your Lordships, but would invite you to read it at some stage. Change of position in particular, he deals with on page 2872. And he refers to the principal group case that I've just referred your lordships to, and also to the Titan case on page 2873. And then 2873, he refers to the Rose group, the Rose v. AIB group that my learned friend refers to, and is rather critical of that decision. And he says, towards the bottom, the judge did not accept the argument advanced on behalf of the liquidator that as a matter of principle there was no room for defence of change of position in the context of section 127. And again, my lords, I would invite you at some stage just to read page 2873 and 2874. My lords, I did just want to take you to the Rose case, which my learned friend relies upon, which is in tab 41 of this same bundle of authorities, and it's at page 2671. My lords, I think we can pick it up at page 2683. Paragraph 39, and it's important to bear in mind we're not dealing with preferences here, we're dealing with section 127. The interrelation between section 127 and restitutionary principles is not a matter which has been the subject of any English judicial decision. He then refers to the Canadian case that I've taken your lordships to, and then says in paragraph 40, I find that case of little help. It concerns a provision significantly different from section 127, that section as it does the power for the court to validate transactions. Now, my lords, that's an important distinction, because when one is considering section 127, or indeed section 284, which is the provision the Court of Appeal were considering in Rearmid, the other case my learned friend refers you to, there is a discretion in the court to validate transactions. Now, one can see why it might be said that in the exercise of that discretion, it would be pertinent to take into account what the recipient had done or hadn't done with the money or the property. That is inbuilt in the section, whereas there is nothing of the kind in section 145. So paragraph 40, he says he doesn't...
The validation provision can't be used for a transaction of this sort.
Well, my lord, the validation provisions are concerned with payments or dispositions of property that occur after the commencement of bankruptcy. So
after the actual commencement of the proceedings.
So, yes, so for example, after the presentation of a petition to wind up, and between that date and the actual winding up, often there are payments made in and out of bank accounts.
Sure.
And so what often happens is that the company will go to the court and say, please, can you validate payments in and out of my bank account? And the court has a discretion. In this case, and in the Armid case, it was particular dispositions that were being considered. But the point I'm making is that it is in a different context, because the court does have a discretion to consider whether or not it should validate or should not validate the transaction. And then paragraph 41, he says, attractively as the argument was presented by Mr. Prentice, I do not consider that change of position can be entirely ruled out as a possible way of resisting a claim for repayment by a liquidator. It seems to me that the question of validation of a disposition is distinct from the question of actual recovery if the disposition is not validated. So not the strongest possible support. He simply says it cannot entirely be ruled out, and he went on to find it wasn't available on the facts. And the only other paragraph I wanted to draw to your lordship's attention is paragraph 42, where he says, I do not consider that the comparison with sections 238 and 239 improves the arguments. Those sections provide express remedies to which the liquidator is entitled if certain conditions are satisfied. So he's drawing a distinction between 127 and the preference and transaction at an undervalued provisions in the English law. And my lords,
But I mean, that seems to be mainly because they provide express rent.
It does. It does, my lord. And I accept that that is a point of distinction between the English preference provisions and the Cayman. And that's why when your lordships read what Professor Good says, one has to be careful, because he has three objections. And the third objection does not apply to Cayman, because the third objection is, he says, the English provisions provide detailed provisions for the remedial consequences. So, my lords, we would say precisely the same as we say about Rose, about the Court of Appeal decision re Ahmed. You'll see that it doesn't appear in that case that there was any consideration of the issue. Lady Justice Gloucester just said, relying upon Mr. Justice Oliver, that common law defences were available. Insofar as I need to go so far, in my submission, Rose and Ahmed are wrong, that as a matter of principle, common law defences are not available to transactions avoiding payments or distributions post-bankruptcy under Section 127 and 284. That's the position or the conclusion that was reached by the Court of Appeal. But I don't need to go that far, because as I've said, they are different. They are dealing with a different set of circumstances. Here, one is dealing with preference. Here, all one has, as my Lord Reid has pointed out, is a statement that the payment will be invalid. But in my submission, there is no room for a change of position, ministerial agency, however my learned friend wants to put it, sort of defence. And there's a further point to bear in mind here. If these really are akin to simple common law claims, every person who received redemption proceeds out of a fund would have an absolutely cast iron common law defence, namely that the payment was made pursuant to a valid contractual obligation. That is the very defence that we were running in Fairfield. And Lord Sumption describes in paragraphs 18 and 19 of his judgment. So Fairfield was a common law claim for money had and received by redeemers who over the years had received the benefits, if you like, of Mr. Madoff's fraud, because they invested in Fairfield and then they'd redeemed and they'd got their money back. And the liquidators said, we want all of that back, because it was all paid under a mistake. And what the Privy Council said in that case was that the banks all had a perfectly good common law defence. Namely, the monies were paid pursuant to a valid contractual obligation, and that was the end of it. They go on to consider the question of whether or not there was a certificate, because in that case there was only, the article was only binding, or the payment was only binding if there was a certificate. But there was also the ancillary argument of good consideration. The banks were all saying, we gave good consideration for those payments, we handed back our shares. And that's found to be a defence. Now, if my learned friend is right, and common law defences are available to a preference claim, every single redeemer would have a good defence. But he's wrong, with the greatest respect to him, because this is not akin to a common law claim for money had and received, money paid under a mistake. It is a claim under a statutory provision that is designed as a matter of policy to ensure that all creditors are treated equally. And it is that policy that requires that if somebody has received money that was a preference and was made with a view to preferring that person, then the money should be repaid, and then that person will share along with the other body of general unsecured creditors. And my Lord, there's nothing in any of that that, in my submission, should allow for individual creditors to pray in aid. whatever their peculiar arrangements are, behind the scenes. And that's why, just on a very superficial and simple level, my learned friend says, it's not fair, I should not have to pay the money back because I was not unjustly enriched. My answer is, but I'm not claiming an unjust enrichment. Whether or not you were enriched or not is not part of my cause of action and should form no part of your defence. Now, my lord, that's
what you say negatively.
yes.
What's the answer to the question, well, what are you claiming in? I think you have to say, don't you, an implied statutory right to recover?
Yes, yeah, I'm claiming pursuant to section 145.
Well, 145 doesn't say anything about recovery, it just talks about invalidity.
No, it says it will be invalid, and therefore, as a result of that, I say by necessary implication.
So you really are relying on an implied statutory right of recovery?
Yes, that must be right, my lord.
Yes, it's no good just saying, I'm not suing in undue.
No.
In that cause of action, I mean, we're entitled to say, well, what cause of action are you suing?
Yes.
I'm just wondering if you have to say that. The side note to section 145 is voidable preference. I mean, the first stage is to avoid the preference. If you do that, I wonder if I imagine, I don't know, but there may be somewhere in this legislation a duty upon the liquidator to ingather the assets of the company.
I'm sure there is that.
Yeah.
As sure as I can be somewhere, that must be right. It is the duty of the liquidator.
Yes.
Lordship.
Well, I mean, I wonder if you avoid the payment. I suspect it does come back to unjust enrichment because you would have to assert some claim to payment against in this case SEB, which you then enforce as liquidator by virtue of the rights you have as liquidator. I mean, obviously, if it were land or something, it would be a different situation. That would be an asset, it would be property you would be recovering. But if it's simply a debt, the debt would arise under the law of unjust enrichment, and you would enforce the debt, enforce payment of the debt.
Yes, I mean, I was just looking at how we put it in our statement of claim, which is in volume 1 of the record, page 236, 237. And you can see, we sought a declaration that each of the payments is invalid as a preference, and then simply an order for repayment.
Well, that doesn't tell you anything about your cause of action.
No.
But I think my Lord Reid has a good point, which is that, of course, it is the responsibility and duty of the liquidators to get in all of the assets of the company. Now, once a payment has been declared to be invalid, then the right to have that money back is an asset of the company. And therefore, it should be paid back. I know Lord Briggs is going to say, I know what you're going to say.
The missing step in that is, where does the right come from?
Yes, I know, absolutely. And
I'm puzzled by the Canadian analysis. I mean, they place their judgment very heavily on the fact that there is a duty on the office holder to get in the company's money. And indeed, so does Professor Good, I think it's fair to say, in his first objection, his first of the fundamental objections, or his second one, I forget which one it is. But that's all very well. If you have a duty to get some money and you go and ask for somebody, he gives it to you, well, you've complied with your duty. If you have to go have a duty to get some money and you ask someone, he says, see you in court, then you have to go to court. And at that stage, you have to assert some kind of recognisable cause of action. It's no good just saying, well, I've got a duty to get the money. The court will say, yes, but what's your cause of action?
no, I understand that, and my answer, I think, is the one I gave to my Lord 5 minutes ago, or my Lord suggested to me, which is that it's by necessary implication in the statute. You have a right to get it back.
Well, yes, I mean, you may want to beware Greeks bearing gifts, but I'm simply asking what else it can be if you decry any common law entitlement.
Well,
following
my
the
Lord,
course of action.
My Lord, it is simply, it's not based, if one steps back, it's not based upon the fact that SEB have been unjustly enriched. It's no part of that field of restitution. It's not based on the fact that it was paid under a mistake. It's no part of that field of restitution. Even if one was to say, well, it's not subject to an implied statutory right, it may be subject to a common law right, I would still submit, in the strongest possible terms, in those circumstances, it is a common law right to which a defence, such as change of position, is not available, in the same way as a defence of good consideration would not be available. Because otherwise, you are denuding the statute of an awful lot of its effect. Because, as my Lord Wilson pointed out to Mr. Shivers, this is going to happen a lot. A lot of these investors are going to be nominees for somebody else. And if that mere fact is sufficient to afford them a defence, then you have torpedoed, to a large extent, the effect of Section 145. And that can't have been what was intended. Lord, that's all I was going to say on whether or not the defences are available. My Lord, whether or not they were available to SEB was a question of fact, which is dealt with in the learned judge's judgment, and that is at paragraph 221 of the judgment, page 152 of the record. And he sets out, 221, the relevant parts of my learned friend's defence. In January, Catella, managed by Catella, was liquidated and dissolved, all the surplus assets of that fund having been distributed to unit holders. There is accordingly no prospect of SEB recovering from that fund the redemption proceeds. In 2009, the management of HQ Solid Mutual Fund, originally managed by HQ, was transferred to another fund. This fund was then merged with another fund. SEBs avers that there is no realistic prospect of it being able to bring a successful claim in the Swedish courts to recover from the OPM Amiga Fund the redemption proceeds. That was the pleading on which the evidence was led in relation to the change of position defence. I.e., what was being said is we now can't recover the funds, not because we're a nominee and always were, but because Catella has gone into liquidation and HQ Solid has merged twice and we don't have a right of recovery against the merged funds. That was the factual basis for it. Evidence was led by my learned friend from Mr. Headman about that, and expert evidence from Mr. Svensson was led about that. And it was during the course of the cross-examination of Mr. Svensson that it emerged that, in fact, the indemnities that were in place for SEB were, from day one, completely worthless. And that, therefore, as a matter of fact, the moment SEB had paid the monies over to Catella or HQ Solid, it had a piece of paper that said it was entitled to an indemnity, but that piece of paper was completely worthless. And it was for that reason that I submitted to the learned judge that on the facts the change of position defence wasn't made out. Because it wasn't because of the liquidation of Catella or because of the merger of HQ Solid that they couldn't recover their monies. It was because they'd always have worthless indemnities. Now, before your lordships, my learned friend does another one of his about turns, and says, yeah, well, that's not actually the change of position defence that I now want to run. The defence I now want to run is that because I was a nominee, I had to pay the money over. I did pay the money over, and I can't reclaim it. Now, that is inherent in the very fact that SEB invested in this fund on behalf of Catella and HQ Solid. And in my submission, that is a matter that the company, the Cayman company, is simply not concerned with, in the same way that an English company wouldn't be. The Cayman company is only concerned with who the legal owner is. That's clear from that Hanoun case I handed up to your lordships in England. It's clear from the 36 building case. And therefore, the shareholder in the fund was, as I think my learned friend accepts, was SEB. SEB ceased to be a shareholder and became a creditor on the 1st of December 2008, pursuant to its redemption notice, and ceased to be a creditor when it received the SEB redemption payments. And that is the end of the matter. SEB, the shareholder, then creditor, was paid, was unjustly enriched, and there is no scope for allowing a defence akin to ministerial agency or anything of that kind, because we are dealing with the company's law here, and the company's law is not interested at all in what is going on behind the scenes. My learned friend says, in paragraph 144 of its case, that the company accepted SEB's status as a nominee. I don't quite know what he means by that. It is certainly true that on the register, and as you've seen from the A5 sheet I handed up, the shareholder is described as SEB as nominee, but that is simply reflecting what was filled in on the subscription forms for the shares in the first place. And your lordships, I don't think we need to go to it, but the subscription form for HQ Solid is in the record, volume 3, page 1436. So that all that the company has done is faithfully recorded what is said on the subscription form on the register of members. But that doesn't enable my learned friend to suggest that somehow we have agreed that SEB is investing as a nominee and we will thereafter deal with the nominee rather than SEB. That's simply not how it works, and not how the legislation intends it to work. So, my lords, not only do we say change of position, etc., not available as a matter of principle, but in fact, on the facts, the pleaded change of position, the one dealt with by the trial judge, not available as a matter of fact, and one is left with what my learned friend now, I think, refers to largely as ministerial agency or nominee, and to which my submission is, no, you can't do that in the context of a company, because the company is only concerned with the legal owner. Otherwise, it can't work. Otherwise, you get into all sorts of difficulties with who can petition to wind up the company, can it be beneficiaries, whatever, and there are a whole host of cases here and elsewhere that say, for the purposes of company legislation, only concerned with the legal shareholder. My lord, the last point, which is a point which my learned friend didn't deal with orally, is the illegality repayment issue. Lords, I don't understand that he's abandoned it. I think he may just have run out of time. if one looks at paragraph 148 of my learned friend's case, it's 1633 of the record.
Sorry, paragraph?
Paragraph 148
Thank you.
of my learned friend's case, page 1633 of the record. Just dealing with this sentence by sentence. SEB's submission was that the JOL's claims to recover the redemption payments received by SEB were founded on Magnus Peterson's fraud. My lords, we say that's not correct. No part of our claim is founded on Magnus Peterson's fraud. Our claim is founded on the necessary ingredients of a claim under 145 as set out in the section, namely a payment to SEB that was, in fact, preferential over other creditors and was, in fact, made with a view to being preferential over other creditors. He then says these claims were to recover the proceeds of the fraud not for the benefit of the company, the victim, but rather for the benefit of unpaid redeeming shareholders. Well, lords, again, I disagree. It was bought for the benefit of the company. Then the liquidators will do what the statute tells them to do and will distribute the monies that they have in accordance with the statutory waterfall that applies in Cayman. Now, it may well be, depending upon other recoveries, but if there are no other significant recoveries, it may well be that the people who get the benefit, if you like, or get what's left in the pot, are the creditors, namely the unpaid redeemers. And that will include SEB. But they won't get 100%, as they have now, of their entitlement. They will get the same percentage as all of the unpaid redeemers. So they will rank entirely equally with the other December redeemers, the January redeemers, and the February redeemers. And that's quite right, because everybody then gets their fair share. My own friends then say, in paragraph 148, the JOL's claim, if successful, would deprive one beneficiary of the fraud, SEB, of the proceeds of the fraud for the purposes of distributing such proceeds among other beneficiaries. Well, the effect of it will be to deprive SEB of its 100% payment, as indeed in the other 24 or so preference actions, if we're successful, we hope to deprive all of the other recipients of their 100% proceeds. And then the liquidators will do what the statute tells them, will do what public policy in pari passu distribution is intended to achieve, and make sure everybody gets their fair percentage. So, my lords, there's no question of the principle of ex turpi causa or any of that kind applying here. All that the liquidators are seeking to do is to treat all the creditors equally, not relying upon Magnus Peterson's fraud to do so, but simply relying upon the fact that they were paid and others haven't been. And then in paragraph 153, my learned friend goes on to talk about members. But my lord, members is not something that section 145 is concerned with. Section 145 is concerned with ensuring a pari passu distribution between creditors. That is why it has to be a preference over other creditors, not a preference over the members. Now, my lords, it may well be that the ultimate effect of Magnus Peterson's fraud is that there is nothing left for the members. That may be the position. I simply don't know, actually, at the moment. But I mean, my learned friend's right, that when he was cross-examining Mr. Stokoe about it in the context of the winding up rules, at that stage there were outstanding claims against Ernst & Young, the auditors, and I think it may have been hoped that they might have been a bit more fruitful than they were otherwise. But the simple fact of the matter is that at the moment we are concerned with creditors. At the moment we, the liquidators, are concerned that they will be treated. And at the moment they haven't been, because SEB and other December redeemers have been paid in full. And that shouldn't have happened, because they were preferred, and indeed the payments were made with a view. And all we're seeking to do is get the money back in and then pay it out fairly. My Lords, unless there's anything else I can assist you on.
Thank you very much, Mr. Lord. Mr. Falk, do you follow? Ms. Chivers.
My Lords, on the fraud point, my learned friend says that the decision of the board is the complete answer. He says any other construction is impossible and it would leave members subject to an open-ended liability. It would always be possible for everything to be revisited. One is hard pushed in this case, of course, to find any decision of the board which constitutes any element of the process by which the valuation was intended to take place. We'll come on to that a bit more when we look at Mr. Magnus Peterson. But the answer to my learned friend's general objection is this. Firstly, if that is the consequence of a fraudulent valuation, that you can reopen matters, so be it. The fact is that a valuation made other than in accordance with the articles is not binding. It doesn't satisfy the contract, and that has certain contractual and quasi-contractual consequences. But you can't pretend that the valuation has been conducted in accordance with the contract just to make life easy for the liquidators. Secondly, the Cayman scheme under Order 11, my learned friend said, didn't affect the position of creditors. It would only affect the position of members. Now, my Lord, that's not right. And I will take you to that in a moment. But that is another solution to this problem. Another solution to this problem, before Order 11 was implemented and brought into Cayman law, this could be done, or indeed it still can, under a scheme of arrangement. And you have a scheme of arrangement between the company and all the members, redeeming shareholders and so forth, and you have a scheme of distribution to try and sort matters out on a fair basis. And of course, restitutionary remedies in any event will evaporate with time, partly due to limitation, partly due to changes of position, and so forth. But the key question in this context is simply this. At the end of December 2008, could SEB successfully have sued the company for a redemption sum based on an unpaid but fraudulently overstated NAV? It's the only thing that this panel has to determine on the fraud point. Because if SEB could not have sued for the fraudulently overstated NAV per share, that's the end of the matter, because then no one else could have sued either. There was no one to whom the company was obliged to pay as against that NAV. Or, as we say, would the company have had a defence by simply saying that the valuation was tainted by fraud and not binding? So that's the issue. My learned friend took you to Primio, It's volume 7, 2424, paragraph 20. And he referred you to a passage which referred to proving in the winding up on the basis of inflated valuations based by Herald on a belief in the genuineness of BLMIS and its transactions. Now, neither Primio nor Fairfield Sentry considered the question of whether the NAV was binding where Herald or Fairfield Sentry knew of the fraud. It simply didn't address that question. Nor in either of those cases was it suggested that the valuation was tainted by fraud in the sense that any person involved in the valuation process on behalf of the funds acted fraudulently. Those were cases on honest mistake, and they were also cases where no person involved in the valuation was dishonest. And it tells you nothing about this case. The expression internal or external fraud may not necessarily be a helpful expression. It's, for reasons which we'll come to, questions of knowledge of the fraud are not decisive in any case. But here, the judge, it is said by my learned friend, made limited findings about the role of Magnus Peterson in the company. Well, not so. And if my lords would take volume 1 at page 80, paragraph 37, it's just worth looking at how the case was put to the learned judge. Paragraph 37. It is a key part of the JOL's case that at all material times, Magnus Peterson and his company managed and controlled the company. On their case, this management and control did not extend merely to the investments carried out by the company, and my lords will recall that's what was delegated to the manager, but all facets of its business, and significantly for the purpose of these proceedings, all decisions about redemptions. The directors, it is contended, played a purely formal role, allowed Magnus Peterson to run things, such that he was permitted by them to be a de facto director. So the case that the liquidators were putting before the judge wasn't in any sense that Magnus Peterson's role was limited. On the contrary, one can look at the evidence, as the learned judge did at paragraph 45, on page 82 of the bundle. On the basis of all this detailed evidence of the role played by the directors, JOL's contends, my learned friend's case, the position was as follows. The directors did not perform any significant role at all, but did whatever was required of them by Magnus Peterson. They simply rubber-stamped his decisions when asked to do so. And then if you go to 3, the directors signed whatever documents they were asked to sign by Magnus Peterson, or practically anyone else. It's true, for example, of minutes of board meetings, financial statements, confirmation letters, specific confirmations to investors, PNC waivers, proposed restructuring, and then the letters, and G, the signing of blank documents. And if we go on to...
That's still a recitation of the liquidator's case.
It's a recitation of the liquidator's case. And then we go on to paragraph 53. The evidence shows that the directors, in effect, delegated authority, including authority in relation to redemption payments, so not limited to redemption payments, to Magnus Peterson, which they were entitled to do. Even if there was not any formal delegation of authority for this purpose, there's a compelling weight of evidence to the effect the board permitted Magnus Peterson to act as a de facto director, and in effect delegated their powers to him. And then, of course, he's dealing with the question of redemptions, but you'll see that that's in, the learned judge accepted the evidence. And then at paragraph 61, I've taken into account, this is at page 91, I've taken into account all the evidence referred to, documents specifically Mr. Stokoe. Having carefully considered such evidence, made due allowance, discrepancies and hearsay, I find that nevertheless the overwhelming weight of it, the effect that Magnus Peterson directly and through his company WC UK managed and controlled the company for all purposes relevant to these proceedings.
Mr.
And-
Chivers, where are you on internal versus external? Your
Well,
case said very clearly, now look, this is internal.
Yes.
You think you've just said 5 minutes ago that it may not be a helpful distinction.
I said that the distinction is not, we say in this case, important because whether a valuation is tainted by fraud does not turn on the knowledge of the parties to the contract in which that valuation is being conducted. This point is nonetheless looking at whether the company was a party to that fraud through Mr. Peterson. So the question is, who's directing this company? The answer, Mr. Peterson, clearly from the judge's findings. The other directors just were rubber stamps. And the issue, when the learned judge says, controlled the company for all purposes relevant to these proceedings, those purposes did include not a U-turn, as my learned friend puts it, but an alternative case that was in the pleadings at the time of the trial, namely that if Magnus Peterson was the controlling mind, then we ran the fraud point accordingly, and we said that the valuations were tainted accordingly. So it's not a U-turn, it was an alternative case that was run before the judge. The learned judge made findings for all purposes. Magnus Peterson was directly, through his company, managing and controlling the company. My learned friend cannot divorce Magnus Peterson from complete responsibility for everything that happened in relation to this company.
One has to read that general finding in the light of what he says about the fraudulent NAV from paragraphs 115 onwards, doesn't one?
Well, it's 115. Yes, my lord, the learned judge dealt with the matter on the basis of the binding nature of the article.
And non-imputation.
Yes, somehow, notwithstanding. Well, I'll come to the non-imputation in a moment, but sorry? It's the tainted by fraud point.
I apologise, but I can't see where, in my learned friend's defence, he has pleaded, or had pleaded, the point that he says was not a volte-face, but was an alternative point about it being tainted by fraud and the determination of the NAV. In fact, in paragraph 17(1) of the defence, page 250 of the bundle, this was his case on the pleadings. It is admitted that upon the 1st December 2008 redemption day, the company became obliged to redeem participating shares in respect of which redemption notices had been duly given prior to that date. The redemption price payable on that date constituted a debt of the company. That was his pleaded position.
Well, my lord, that's still my position today. I haven't moved from that position. The pleaded point was that Magnus Peterson's fraud infected the valuation. That was directly before the judge. And if we're looking at questions of Magnus Peterson's role in the company, the findings of the judge relate to that point. My lord, what is clear is that there was no one other than Magnus Peterson who directed the company's affairs. So far as the administrator's role is concerned, it's clear at paragraph 61 of the judgment, page 90, paragraph 60, that the role was purely administrative, and one sees at paragraph 58 it was to calculate, compute the net asset value. It was not delegated any powers of valuation. The valuation functions were set out in the offering memorandum, and my lords have seen those. They were reserved to the directors, either directly, in respect of securities that weren't listed, or indirectly by putting a valuation methodology which was to be followed. But in no case did the administrators have any authority themselves to value or to put a value on anything that wasn't a market value or something. And if they did, this wasn't a valuation in accordance with the articles, even without fraud. The articles, this was not a valuation that they were instructed to do. But whatever function held by PNC, the provision of false information to the valuer will vitiate the valuation.
Have you just said that a non-fraudulent mistake in identifying the NAV would make it in...
No, my lord, with respect, not a non-fraudulent mistake in identifying the NAV, a mistake in carrying out the task that contractually the valuation was, that the way in which the valuation was to be conducted. The contract says the valuation must be conducted in this way. If it is conducted in a different way, it's not a valuation in accordance with the contract. So if the directors are given discretions in the articles as to valuation, and they delegate other powers to the administrator, which are not valuation powers, and the administrators purport to value, then the administrators are not doing the job that has been delegated to them, and it's simply not a valuation in accordance with the articles.
So a non-fraudulent...
Incorrect. The process is incorrect.
A non-fraudulent identification of the NAV, which was in breach of contract,
yes,
would render it invalid.
Yes, it's the contract, my lord. That's absolutely right. It's a question of was this valuation carried out in accordance with the contract? And from the valuation cases, it's absolutely clear. The one thing the valuer must do is follow the terms of the contract. Otherwise, it's simply not a valuation in accordance with the article. Now, my lord, so far as the swaps were concerned, my learned friend says, well, these were genuine documents, they weren't worthless. It's a rather strange submission. If one looks at Mr. Stokoe's evidence at volume 4, my learned friend took you to this. Well, I won't take it to you to it again. My lords will see that on the master agreement, it appears that Magnus Peterson forged both signatures on the master agreement. It's not a very good start for saying that there are valid contractual transactions entered into in consequence upon a forged agreement. And the letters of existence of swaps and expressions of value, my learned friend took you to those. It might be worth just picking those up for a moment and having a look at what these say. My learned friend, what he said was, well, he said, this is a document coming from a third party, Weavering Capital Fund. And if that's relied upon and there's fraud at the Weavering Capital Fund level, that doesn't taint the valuation. Well, first of all, this doesn't come from Weavering Capital Fund. It's just a bit of paper that says Weavering Capital Fund on it. It purports to be signed by a director of Weavering Capital Fund, although that, it appears, was the signature of Magnus Peterson in forgery. So we have a forged document. How a forgery can be regarded as coming from the third party isn't clear. The document that my learned friend relied on, and so far as the valuation is concerned, it's just worth looking at this as well. At the bottom of the very last line, this results in our value of the interest rate swaps being $98 million. Now, if PNC simply plugged that value into the valuation process, that certainly wasn't in accordance with the contract. The one person who couldn't value the swaps was the counterparty to the swaps. That doesn't amount to a director's valuation at all. But in any event, these swaps had to be valued by the directors or in accordance with the methodology set by the directors, and clearly they weren't. Or to the extent that they were by Mr. Peterson, he did so fraudulently. But well, the other thing, just to note very quickly, the other document my learned friend took you to at 460, she said, well, here is a genuine document, he says, from Weavering Capital Fund Limited in Tortola. It refers to the ISDA master agreement, which appears to have been entered into on the basis of forged signatures. It's received, my learned friend says, in Ireland at 5:25 p.m. It was sent at the bottom, you'll see upside down, it was faxed 1 hour earlier. Apparently, it doesn't appear to have come from Tortola. Now, of course, it wouldn't have to. But, my lord, there's no evidence of any genuineness of these documents. But even if there were, it makes no difference, because to the extent that any person relied, to the extent that PNC relied on the statement of value on the front page, it had no entitlement to do so. To the extent it did, that wasn't a valuation in accordance with the contract. To the extent Mr. Peterson, who was the only person, as the judge found, who was exercising any discretion in the affairs of the company, well, he knew that that was worthless. And if he gave that to PNC, this is sent to the fund. If Mr. Peterson gave that to PNC, either in his capacity as de facto director of the fund, or in his capacity as agent of the fund, to whom powers had been delegated to WC UK, he did so knowingly, knowing that it was fraudulent, knowing it was dishonest, and with the intention that it would result in an incorrect, overstated NAV. That was the whole purpose of these swaps. So, to the extent that Magnus Peterson was involved, he was involved up to his neck in this whole process, he was dishonest, and his actions in allowing these documents to get into the hands of the administrators without telling the administrators that they were worthless, that was dishonest and tainted the valuation. The valuations were not conducted in accordance with the articles. So as far as Hampshire Land is concerned, the point appears to be this. My learned friend is saying, well, you can't attribute Magnus Peterson's knowledge as, I think he's saying, a director of WCK to his knowledge as a director of the company or de facto director of the company. But there's nothing here to suggest that any relevant knowledge came to Magnus Peterson other than as de facto director of the company. After all, no one else knew anything about the company's affairs except Magnus Peterson. The directors didn't. The jury directors didn't. He was the only person who knew. Of course his knowledge was the company's knowledge. But so far as WC UK is concerned, I'll come to Jativa in a moment. The question, and the reason why I suggested that this issue of internal-external fraud may be unnecessary for the court to go into, is not because the question is whether the company knew about the fraud, but whether the valuation is binding. That's the issue. Is the determination of NAV binding? Now, if A and B instruct C to value a property for the purpose of a sale between them, neither is bound if C submits a dishonest valuation. The contract may say that the valuation is binding, but as the valuation cases show, binding, that the valuation means an honest valuation. It means a valuation conducted in accordance with the contract, and a dishonest valuation is not conducted in accordance with the contract. It doesn't depend upon any attribution of knowledge to A or B. If either of them, after the event, discovers that that valuation was dishonest, it's not binding. It's not a contractual valuation. Now here, the company delegated the calculation of the NAV to PNC, not its valuation, but the calculation. If the controlling mind of the company, the de facto director, provides dishonest information about the value of assets for the purpose of the calculation, and that valuation has not been conducted bona fide, and it's not binding. attribution of knowledge is irrelevant. And even if the dishonest information comes through WCUK, makes no difference. The company on this hypothesis delegated the provision of valuation information to WCUK. If WCUK provides dishonest information to PNC, again, the valuation is not binding. Because an element, a person whose responsibility it was, who owed an obligation to the company to provide information in good faith, provided that information in bad faith. Again, attribution of knowledge is irrelevant. So the fact is, whether the valuation is conducted by the board or whether the board delegates that task to different persons in different aspects, if any person to whom the task has been delegated and who is involved in that valuation process and fitting it together, so it's delegation from the board, let's say to WCUK on the one hand and to the administrators on the other, they talk to each other to produce the final figure. If either of those parties, in talking to the other, is dishonest, the valuation is tainted. It's not binding. Now, Hampshire Land might have been relevant in Primio if there'd been a common director of Primio and BLMIS. Then the question of attribution of knowledge, whether it was a bona fide, an honest mistake, would have come into play. I would say if BLMIS had undertaken to Primio to provide valuation services, then the valuation would not have been binding. But if the question is whether the company knew about the fraud, clearly it did. So as far as Strativa is concerned, my learned friend took you to passages which, paragraph 43, and I won't take you to it, it's at V7, volume 7, 2174, paragraph 43. He took you to the passage that said the rules of attributions for the purpose of establishing, he took you to the part which said, well, where the company is suing the director or the director is suing the company, questions of attribution of knowledge may shift for one purpose or another. And then went on to say, which my learned friend didn't take you to, the rule, paragraph 43, the rules of attributions for the purpose of establishing or negativing vicarious liability to third parties differs necessarily from the rules governing the direct relationship inter se of principal and agent. So if a third party is dealing with the company, a shareholder for these purposes dealing with the company, questions of attribution as between the company and its director for the purpose of the company suing the director or the director suing the company are wholly irrelevant. We're then just dealing with ordinary rules of vicarious liability. Otherwise, no company would be liable for the fraud of its directors. You can't just cast them off and say, no, look at the rules of attribution. When a director is fraudulent, his knowledge is not imputed to the company. That's so that the director, in a claim by the company, or someone connected through that claim, can't rely upon the company's knowledge. Now, so far as the winding up rule is concerned, Order 12, my learned friend said it applied only to members, not creditors. That's not right. It's at volume 8, at tab 57. And it's at 2840 of the bundle. And this is about settling a list of contributories, rectification of the register of members, Order 12, Rule 2. The official liquidator shall exercise his power to rectify the company's register of members if he's satisfied the company is or will become solvent. It doesn't have to be solvent, will become solvent. B, the company has issued redeemable shares based upon a misstated net asset value which is not binding by reason of fraud or default, with the result the company has issued an excessive or inadequate number of shares in consideration, and or the company has redeemed shares at prices based upon a misstated net asset value which is not binding on the company and its members by reason of fraud or default. The result the company has paid out excessive or inadequate amounts. For the purpose of rectifying the register of members, liquidators shall determine the true net asset value as at each relevant redemption date. And then 4, the register of members, when rectified, shall state at each relevant redemption date the identity of each subscriber, the amount of money subscribed, the number of shares which ought to have been issued to him, the identity of the member who redeemed, the number of shares redeemed, the amount of redemption proceeds which ought to have been paid to him, and the identity of the company's members, number of shares which ought to have been held, and the company's share register shall be rectified accordingly. So it does have retrospective effect. Now, my lords, I don't have time, I'm afraid, to go further on that, just to say that Cayman legislation has addressed the question of restating NAV and going back and looking backwards to it. But, my lords, we don't need to go any further on that. The restatement of NAV itself, though, was admitted by Mr. Stokoe in cross-examination, and very quickly it's at Bundle 2, at page 676.
Sorry, can you give me that page again?
Yes, 676.
Thank you.
Of the record. Lines 16 to 25. Mr. Stokoe said this: I think it's inevitable that there will be a need to restate the NAV to reflect the fraud and the effect of the fraud on the NAV. It's not Mr. Stokoe who was the liquidator. He'd retired just before this, but he was the liquidator and gave evidence because he knew about it. But to do so at that stage would have incurred an expense we couldn't have properly funded, massive exercise. So the methodology needed to be established, context of whether there'd be any funds available for distribution that made it worthwhile. So we decided we'd wait and see what the position was as regards realizations before moving forward with any thought on how it would be done. And then at page 258, we'd have to address what the quantum of the redemption of creditors was, needed legal advice, certainly a direction of the court, as to whether we should seek to restate the value of the current claims on the basis of the misstated NAV. It's not just a theoretical aspect, this is what the liquidators anticipate at the time of the trial. My lords, I must move on to the 30-day point, and I'll deal with this in 3 answers to my learned friends.
I'm sorry to interrupt you, but
Yes.
Are you going to deal with the points that Lord Briggs raised in relation to ground 1?
Oh, my lord, well, yes, this would probably be a convenient moment to do that. Let me just...
I don't want to take you out of your order.
No, no.
The same ground.
My lords, it's obviously sensible to do that. I can just pick up my notes. Yes. So, my lords, the way the question was put was whether the NAV would be void or voidable. I think one has to understand the way in which we put our case, and that is the test that I set out. As at the end of December, could SEB have sued the company in respect of the fraudulent NAV? That's the question. We're not concerned with the company taking positive action at this stage to do anything about it. We're simply concerned with who are the creditors who are entitled to be paid. Could the December redeemers have gone to the company and demanded payment, or would the company have had a defence based on the fraudulent miscalculation of the NAV? And that's the issue. So the question of void or voidable, we say, doesn't actually arise. The question is, has there been a valuation in accordance with the articles?
And so you say if the answer is that SEB could not have sued for payment of a fraudulent NAV, then it follows that they, and indeed the other December creditors, December redeemers, aren't creditors within the meaning of Section 145.
Yes, that's right. Yeah. So the question of whether in some other action someone might seek from the court a declaration that the NAV is void, we say doesn't arise. I'm not concerned with what other actions or other claims might be brought consequent upon this particular calculation of NAV, and whether or not the court would say, well, we'll treat it as valid until such time as it is avoided. So cases of, I don't know, fraudulent misrepresentation or something like that may raise issues of that nature, I don't know. But well, that's our approach to it. One simply says, could SEB have sued for the money, or would the company have had an effective defence? And if the company would have had an effective defence based on the fraud, that's the end of the matter, we say. Whether in other proceedings between persons, some person might at some stage say, I seek to avoid this valuation, we say it's neither here nor there. The question is whether that valuation is binding as between the company and SEB on the terms of the contract. This isn't a question about avoiding a contract, my learned friend referred to, not a question of rescinding a contract. It might have been, let's suppose that a redeemer said, well, I want to rescind my notice of rescission. I want to rescind my subscription application because my subscription was based on the fraudulent NAV. You made a fraudulent misrepresentation, I want to rescind. Or let's suppose there'd been an understatement and the shareholder said, I want to rescind my notice of redemption because that was based upon a fraudulent miscalculation. There the court is looking at rescinding and so forth. But here we're looking at the performance of a contract, not its rescission. And the only question for this court is, has the contract been performed in accordance with its terms? Well, Lords, I hope that's a sufficient answer. Whether it's adequate or not will be for my Lords. My Lords, the 30-day point, I say just 3 points to make in answer to my learned friend. Firstly, at best for my learned friend, the articles are silent on the time for payment. In that case, the law implies a reasonable time. My learned friend didn't challenge any of the authorities or even the proposition to that effect, and nor have they pointed to evidence that 30 days was not, in all the circumstances, a reasonable time. Second point, my learned friend went into some detail to strategic turnaround, but he carefully avoided paragraph 33 of that case, which Lord Mance clearly identifies two ways in which the company might not be liable as a credit to a person to pay as a current creditor. And the first of that was the 30-day period determined by the directors, the combination of article and the offering memorandum. And Lord Mance said, well, that gives them, the directors have determined that 30 days is the reasonable period. And then he went on to consider the second basis, which was the suspension. That didn't work, but the 30 days had passed. So the articles in this case, indeed, they're not silent on the time for payment, and the offering memorandum makes clear what at least the outer limit of that determination must have been. And thirdly, my learned friend said, well, in Primio, the grace period was just for convenience. I'm not sure what that means. It's not very convenient if someone's able to wind up the company. Lord Mance's short period of credit, as he referred in Primio, is just that. A period of credit is time to pay. You cease to be, or you are not, a creditor who can come for immediate payment. You have given credit to the company, and you have to wait until that period of credit has expired before you can go and say, pay now. On the future debts point, firstly, of course, as strategic turnaround shows, the Privy Council upheld the view of the court below that what was relevant was whether there was a debt immediately payable, not payable in the future. That was what the court was concerned about, and the Privy Council was concerned about in strategic turnaround. Was this debt payable now, or is it payable in the future? If it's payable in the future, you can't petition. If it's payable now, you can. That was the question. And they held it was payable now, 30 days having passed. But so far as the legal test is concerned, there was no question at all that the debt had to be immediately payable. There was no element of futurity at all. My learned friend said that the future debts, it meant a wide, flexible, fact-sensitive test, and that's simply not a submission consistent with European life assurance. My Lords, I'll leave my Lords to consider whether Lord Walker's test for cash flow insolvency relates to the wording of this particular statute. The submission it clearly doesn't. Lord Walker was not seeking to overturn European life assurance. If he thought it was wrong, he didn't say so. And he certainly
Got quite near to saying so.
He didn't like it.
No.
But, my Lord, the point that we
He
made...
said it's unfortunate that it had been treated as a leading case.
It's unfortunate, but it has been treated as a leading case, and as we've indicated, if a legislature passes legislation in identical terms following the leading case, it must be taken to have that meaning. That's the Olympic point. The decision in Olympic, clearly, people thought was wrong. It wasn't a wreck if two ships hit each other and both of them can sail off. One might think neither of them had been wrecked. But the answer in the Olympic case was they had been wrecked. And so when subsequent legislation used the word wreck, it meant the same thing. However much you may doubt the case, it is a leading case. Of course, Lord Walker didn't need to say it was wrong because he was dealing with completely different legislation. But there are two things about the schedule my learned friend showed you. Firstly, it was dealing with a balance sheet test, not a cash flow test. The value of the swaps would have been irrelevant to solvency within the meaning of the Act if cash flow could have been managed. And the second thing to note about it, interestingly, is that subscription monies were still being received throughout this whole period. December, January, February. There were still millions of dollars coming in by way of subscription monies. Magnus Petersen wasn't simply catching the balls as they came down, he was throwing new ones into the air. So, whatever one might think about Magnus Petersen's views as to whether this company could continue or not, it was still being run in the ordinary course, for good or bad. My learned friend said that the test unable to pay debts to say that includes a consideration of future debts makes perfect common sense, he says. So it might, but it's not the settled meaning of the phrase. And it's simply a matter of choice. One can define insolvency in a number of different ways. And it may be considered in terms of, it may be considered anomalous in terms of the fraudulent preference test, as my Lord Briggs pointed out. It's easier to swallow perhaps in the context of a winding up test. Who can petition? Well, you have to draw the line somewhere, and you draw the line, you say, well, you can only petition on the ground of insolvency if you can say you actually haven't been paid something that was due to you. But in any event, it's perfectly proper for the Cayman legislature to prioritise certainty of receipt over recovery to an insolvent estate. My Lords, dealing with the question of fraudulent preference itself, I would ask the panel just to ask itself this question. Why did Magnus Petersen pay the December redeemers before the January redeemers? That's the question. Because if there is no rational reason to suppose that he wanted the December redeemers to be in a better position than the January redeemers in winding up, then there can be no preference. A payment made by way of preference is intended to put that person in a better position than they will be in the winding up as against some other creditors. But there's no rational reason why Magnus Petersen would have wished to put the December redeemers in a better position in the winding up than the January redeemers. And of course you can infer certain matters from facts. But looking at this list of names, some of which appear in different schedules, it's impossible to suppose, rationally, that Magnus Petersen cared at all about people he had defrauded and was continuing to defraud. Why did he care whether the December redeemers came out of the winding up better than the January redeemers. There is no rational explanation, and my learned friend hasn't put forward any rational explanation. All he can point to is the fact of preference, and he says that's all you need to know. As he said, when he took you to the preliminary issue, his submission was the question answers itself. That's the point, it doesn't. And it's not as if there are not plenty of other reasons that Magnus Petersen may have wished to pay the December redeemers first, not least because they fell due for payment first and he was putting off the evil day. And the learned judge accepted at first instance that there may well be other reasons which would apply if you didn't have the particular animus towards a particular creditor. So, my lords, that, I think, is the fundamental question here. This just doesn't look like a preference. There is no, you cannot identify any creditor in the list who Magnus Petersen would have said, I want you to be in a better position than someone in the January list. So far as the policy is concerned, the 75% policy, that wasn't a policy to bring forward payment of the December redeemers, that was deferring them. They were due on the 1st of January, 31st of December. This policy was deferring the December redeemers.
Is the most awkward aspect from your point of view the non-payment of the 3 large December redeemers?
No, with respect, no, my lord, because again, you cannot identify any reason why Mr. Petersen would have wanted SEB for HQ Solid to be paid before HSBC nominees. Why would Mr. Magnus Petersen have wanted SEB to come out of the liquidation in a better position than HSBC? He clearly didn't. He didn't care. The reason that HSBC wasn't paid is because they ran out of money. That's why it wasn't paid. He just paid till he paid to get rid of creditors as best he could, bottom up to a degree, the smaller ones first, because then you get rid of the number of creditors. And he clearly took the view that that was the best way to deal. He had fewer people. The December redeemers weren't being treated equally. No, they weren't.
They weren't paid pari passu, no, even if there wasn't enough money to pay them all in full.
My lord, they weren't, but that's effect. We're looking at effect.
I know, but we're then having to go on to see whether from effect it is fair to infer intention.
Yes, but my lord, again, one has to say, well, what is it about these creditors that meant Mr. Petersen wanted to put them in a better position than the other creditors? And there is nothing. He clearly didn't want to. He didn't care about any of them. They just happened to appear on a list with particular numbers in a particular order. They might have just been numbers for all he was concerned with. The names didn't matter. And there is no case in which the identity of the payee did not matter that has been found to be a preference. Sorry, my lord.
Sorry, did the judge not find, though the Court of Appeal disagreed with them, that the Swedishness of the fortunate redeemers in the 19th of December?
Well, not the Swedishness, but the fact that SEB had been preferred in respect of the other account. So Catella, the Catella fund had been preferred because Mr. Petersen thought Catella would invest in another fund of his. But as the Court of Appeal found, that couldn't have affected his state of mind. And in any event, if you look at the December schedule, there's no evidence that SEB had been picked out for special treatment. On the contrary, it was one of the last to be paid.
You say that the judge found that he thought that Catella would invest in his Swedish fund. Surely the more accurate way of putting it is that he said he thought that Catella would invest in the Swedish fund. What was going through his mind in including Catella for early payment is very open.
Well, my lord, the point was argued before the judge, and the judge decided that Magnus Petersen must have had that state of mind. That was the finding he made from the evidence. But, my lords, the issue of preference in this context, as say, there is no case in which the actual identity of the payee has been wholly irrelevant, where it's been found to be a preference. Cohen comes the closest, where an identified payee was there, And the court said, well, we don't know why this one was chosen, but the facts show, for some reason that we don't know, this particular one was chosen. Now, in that case, interestingly, the court said, well, it was suggested that they should have asked the payor. Well, that's a ridiculous suggestion. Interestingly, of course, here, the liquidators could have asked Mr. Peterson because they interviewed him. Mr. Peterson cooperated with the liquidators. I know he was in prison at the time of the trial, but as liquidators do, they interview directors and so on under their statutory powers, and Mr. Peterson cooperated. And there was a transcript of the interview, and not once did they ask him why he had made these payments. Not once did they ask him why he had paid the December redeemers before the January redeemers. So they had the opportunity to address it, but instead of addressing it like that, they asked the court to draw an inference from the mere fact of preference, and that is hopeless. My Lords, Lewis and Hyde, if I may move on, my learned friend says, well, in that case, the payment wasn't a preference because it would have been paid in the ordinary course. The facts are materially identical here. If the 19th of December payment hadn't been made, those Catella would have been paid out under the 25-75% policy. Therefore, as at the date of the liquidation, it would not have been a creditor, and those funds would not have been there. So, in fact, the first payment did not prefer Catella. It was made with a view to preferring Catella, but it did not, in fact, prefer Catella because had that payment not been made, at the onset of the liquidation, Catella wouldn't have been a creditor, and that £1 million wouldn't have been there. It would have been paid out anyway. So it all turns on the second and third payments. If those are preferences, of course, then the first payment would be found to be a preference. But otherwise...
The principal point was that was made against you was that whatever the intention or absence of intention to prefer on the second and third payments, they were nonetheless preferences in fact.
Well, my Lord, yes, but in Lewis and Hyde, so were all the payments made to the creditors who were paid out of Prudential, the millions of dollars that were paid out to all those creditors. They were all preferences as well. It's simply that because they were paid in the ordinary course of business, they couldn't be challenged as voidable preferences. So to the extent that Mr. Hyde would have been paid out in the ordinary course of business, it couldn't be challenged. But the rationale is the passage that I took you to. The rationale of the section is not to increase the assets beyond that which they would have been had that particular payment not been made. Well, Lords, coming on then to the question of unjust enrichment. My Lords, unjust enrichment, the lack of enrichment was pleaded as a defence by us. It's in the pleading, it's in the re-amended pleading. So the question was and has been there throughout. Now, my learned friend says these defences are not available. He says they're not available because he has an implied statutory cause of action. There is no authority for the existence of that implied statutory cause of action that he has taken you to. I don't say examples cannot be found, but it's a little difficult for me in the abstract to answer a case that hasn't been developed by my learned friend. Its failure to identify the cause of action leaves me in some difficulty if it is not that which such authorities as there are in relation to preference identify as being common law. We say the answer is very clear. They're clearly common law causes of action. And then the question is, what is the consequence of that? Now, my learned friend went a little aside here, and he said, well, there can't be an unjust, you can't claim that you haven't been enriched because company law is concerned only with legal ownership and not beneficial ownership. And he elided two things there. One, the English, the UK statutory regime, which specifically provides by statute that notice of trust shall not be entered on the register, compared to the Cayman regime, which says nothing at all on the subject. And here we have a register with a notice of trust entered on it. He then took you to Hanoun, which is a question of who's a contributory, and the rather difficult question of the circumstances, exceptional circumstances in which a beneficiary can bring a derivative action. But I don't seek to re-argue the point at all, but at paragraph 8 of Hanoun, it says this: if the beneficiary of a bare trust whose existence and identity have not been disclosed to the corporate directors is permitted to step out of the shadows and seek the dissolution of the company in which he has an indirect interest, the law would be expanded undesirably. Now, this isn't a case where we're stepping out of the shadows. This is a case where we have always been on the register as nominee. And indeed, we're on the payment schedule as nominee. So when the company paid us, it knew it was paying us as nominee. It knew that the payment was not enriching us, but was going to enrich the beneficiary. So whatever the position in case of an undisclosed principle, my learned friend's point, so far as that goes, takes him nowhere. Okay. We have not... Sorry, my lord.
Well, I'm sorry, I was just going to ask, that there is authority on the question whether a payment to an agent enriches the principal.
Yes.
I haven't found any authority on the question whether payment to a trustee of any kind can be treated as not enriching the trustee, but rather enriching the beneficiary. I wondered if you knew of any authority.
Well, I had hoped that in my first round of submissions, I had addressed that in the case of trust. I thought it was Lord Justice Millett.
Oh, yes, yes.
And I think I tried to cover it in the case of trust and then in the case of banker.
Thank you very much.
So I hope
I'll find that.
I hope that's helpful. I considered the agency point because, as my lord says, there are authorities,
yes.
But it seemed to me that where we're expressly a trustee, I thought that was the appropriate test here. And then my learned friend relies on 38 buildings, and the passage at volume 8, 372619. It's perhaps just worth referring to that very quickly. It will take a moment. At 2619. Trace this in aid to say that the preference legislation is only concerned with the person who's the creditor and not a person who's behind the creditor. And what was said at G, in my judgment on its true construction, 2394, is looking to identify a creditor in the legal sense of the word, and then treats repayment of that creditor as the giving of preference. At that stage, it matters not whether that creditor is a creditor in a trust capacity or in a beneficial capacity. Well, we haven't argued with that. We haven't argued that if the preference was paid to us and is avoided and so forth, the preference legislation doesn't bite. But as the learned judge said in that case, at that stage, that is the question. The question we're concerned with is what happens next? What happens if it is avoided? And of course, the question of beneficiaries is not without importance, because the reason we were preferred is not because Mr. Magnus Peterson had any fondness for SEB, his former employer. It's because Catella was going to invest in another fund of his. So the preference claim that my learned friends bring looks through the beneficial, looks through the legal interest and actually looks at the beneficial owner. It only makes sense if you take the beneficial owner into account. If you ignore the beneficial owner altogether, as my learned friend says you should, there's no evidence at all of any intention in the first payment to prefer SEB. Mr. Magnus Peterson couldn't have cared less about SEB. It's because of Catella that the preference is there. And finally, my learned friend said that there was no, quite finally, he said there were no cases in England, Cayman, BVI, and that's, of course, because creditors are generally creditors. They're people who advance money to companies. They don't do it through trusts, as a rule. The reason this has occurred in Cayman is because Cayman has separated out redemption of shares from payment of shares and has created a class of creditors which the common law world finds novel. And that's why it's come up. The reason that these creditors are stacked full of trustees is because they were shareholders, holding as nominees. These weren't people who advanced money to the company as creditors. The preference rules were built up for a regime where people worked for the company or did work for the company and were owed money or provided them with goods for which they hadn't been paid. That's the hundreds of years of development of preference law. The fact that in Cayman we now have a curious situation, which the can of worms opened up by this panel in Primeo, if I may say so, which separates out redemption from payment. There was a chance to makes my metaphors, put the genie back in the bottle. But the Privy Council didn't take that. And so we have this situation. Yes, it is unprecedented. Of course there aren't authorities relating to this. Because generally when you're a creditor in your own right. Why would these issues tend to arise? So far as Good is concerned, Professor Good was wrong. Rose and AIB shows him to be wrong. My learned friend relied on Rose to say, well, there's a discretion in 127 to validate, and that somehow encompasses the equitable defences that might be run. Not so. The learned judge in Rose first dealt with validation under 127, and secondly, dealt with the question of whether, having not validated, there was an equitable defence. They're two distinct issues. So one doesn't just elide them, and the statutory purpose behind them is exactly the same. It's identifying the date of the liquidation and saying, what are the assets as at this date? What assets are we bringing in, either from before or from after? But they both have exactly the same purpose.
Do you want to say anything about the duty analysis in the Canadian case?
My Lord, so far as the Canadian case is concerned, the legislation is slightly different. If one looks at it on the question of a duty of the liquidator to get in assets, of course the liquidator has that duty in respect of all assets, whether or not they arise from the return, an avoidance of a preference. So a transfer of property, that property now remains the property of the company, and the directors have an obligation to get it in. And the Canadian legislation makes some specific provision in that respect. The position so far as other claims, if the liquidator brings a claim that the company has against a third party, that third party can rely upon equitable defences because the liquidator's claim is subject to the equity. So the liquidator's obligation is to get in a claim subject to any lawful defences which can be raised. And indeed, when one looks at the position, when the liquidator is seeking to deal with proofs and payment out, the liquidator has to address questions of set-off, and those set-off will take place having regard to the beneficial owners of the debt, not the legal owners of the debt. So equity comes into play at the pari passu stage in any event. So there's nothing to suggest that the liquidator's obligation to get in assets is somehow some super cause of action which overrides equitable defences. On the questions of fact, my learned friend said that we had made another U-turn in respect of our change of position argument. No, our change of position argument has simply been brought forward. We said we'd changed our position by paying out, because that's when the indemnities became worthless. The expert evidence that the judge found the indemnities were always worthless, so we changed our position ab initio. It simply brings forward the point. My Lords, then there was a question of my learned friend's point on illegality. Again, I just refer you to our skeleton, but just to make clear what the point is here. There has been a fraudulent determination of NAV. Redeeming shareholders have been overpaid. The victims of that fraud, they are the beneficiaries of the fraud. The fraudster didn't intend them to benefit, but they are the beneficiaries of that fraud. The victims of the fraud are those members who have not redeemed. They are the victims of the fraud, where there's been an overstatement. If there had been an understatement of NAV, it would be the other way round. The people who had been paid out would be the victims of that, and the people who were still members would be the beneficiaries of that. This action is not intended to protect the victims of this fraud. It is simply intended to redistribute the proceeds of that fraud amongst the undeserving beneficiaries of that fraud. And that is the extent of the illegality point. I hope that explains the point. So it's the shareholders, if what the liquidator says happens is that this is going to be redistributed amongst the creditors, it's being redistributed amongst people who shouldn't have had it anyway. And there's no equity in the liquidator to do that. So far as reliance on the fraud goes, they're relying on the fraudulently overstated NAV to say that the money can be repaid and redistributed to people who they say are creditors based upon that fraudulently restated NAV. They know it was fraudulently stated, and yet they continue to persist in trying to redistribute on that basis. The proper thing for them to do, to echo some words of the judge, so far as Mr. Peterson's concerned, the proper things for the liquidators to do would be to look at the position under Order 12 and say, well, what we need here is a recalculation of everything. If what we're trying to do is to redistribute the limited assets available, then we have to do that on the basis of fairness between all the victims of the fraud, not simply those who were lucky enough to redeem on the false NAV prior to the company going into liquidation. So that would be the proper course. And indeed, that's the course Mr. Stokoe said he thought was inevitable in evidence. That was the vice here that we were concerned with, the liquidators trying to recover monies on the basis of the NAV being binding, while saying all along, no, we're always going to treat this as not binding and go to the court and get it all redistributed amongst the members as well. My Lords, there's much else I could say. If there's anything specific that I can assist my Lords with, I'll attempt to do so as quickly as I can.
I don't think so, Mr. Chivers.
Lords, thank you very much.
Well, this is a very interesting appeal, and it raises a number of important points. The board is very grateful to counsel for skillfully presenting the arguments to us within a day and a half, and we're grateful to all those who've been involved in preparing the appeal. The board will now take time to consider what advice it will humbly tender to Her Majesty.